going into public session. Okay, so members, I'm just going to remind you that this meeting is being broadcast online and throughout Parliament buildings. So just welcome the panellists now into the room and those that will be sitting in the public gallery today, and also to welcome anyone who is watching online, as I say. So if we can ensure that all mobile phones are muted and that no photography or recording of the meeting is allowed. So if members are content, good afternoon, Sinead. If all members are content, we'll proceed through the agenda. So we have received apologies from Carol and Harry, and I think everyone else is present, and we have Stuart Dixon is joining us online today. So in terms of declarations of interest, does anyone have any to declare? No? Okay. And in terms of chairperson's business, just to advise that I attended the Interparliamentary Forum. We had it here in Parliament buildings on Friday. I was joined by the chair of the Finance Committee, Matthew O'Toole, and I think it was a very successful event. It was the first time it had been facilitated in the Northern Ireland Assembly, and I think all the visitors really enjoyed it. One of the issues that did come up was something that we as a committee discussed last week, and that was the common frameworks and the delays in the department, the executive, getting those signed off. So obviously the Interparliamentary Forum is also interested in this area, and they were going to write to the Executive Office for an update, and I said, well, we've already done that, and so I'm just asking for your agreement that when we receive our response from the department that we can share it with the members. Everyone content? Okay, thank you. Okay, so moving on then. So earlier this week, the clerk and I met with Professor Alex Jay. She has been appointed by the Executive Office to conduct an independent review of the Office of the Commissioner for Survivors of Institutional Childhood Abuse. So we met with her on Monday, and I think she's maybe written to all the parties individually for meetings, so if you haven't responded yet or haven't engaged with her yet, I would encourage you to do so. But I would just ask your agreement that we write to the department to ask for an organisational structure of COSIC and any associated costs. Is that okay? Okay, so members, this morning the clerk and I met with some women who have been involved with the Victims and Survivors Consultative Forum relating to the mother and baby homes, etc. And they did raise some serious questions around whether or not a gender-informed process was being followed, not least a trauma-informed process. They have some concerns about the consultation around the inquiry, forthcoming inquiry into mother and baby homes, and I know we took evidence from representatives of the panel, independent panel in the past, but I think that we need to hear some more voices. So with your agreement, we were going to invite them in the new year, plus some representatives from the mothers, birth mothers and their children for justice, if people are content with that. Okay, they have committed to sending some written information, and also they have some suggestions for how that work could be improved. So we'll share that as soon as we receive that, okay? Just to give you a wee bit more understanding. So draft minutes, members. So there are a set of amended draft minutes of last week's meeting, the 13th of November, and they're found at pages 3 to 10 of the table pack. And there's one minor amendment to those circulated in the main pack. What was the minor amendment?
It was just, you had said that the minutes to the meeting with the FM were an accurate portrayal of
so
the
you
meeting, so
that.
it was just to add that to the minutes there.
Okay, so are members content that they're a true and accurate record?
Sorry, could you just repeat that point?
It hadn't been included in the first set of minutes that went out that I had said at the meeting that I was content that they were a true representation. So
the discussion is there, but the fact that the chair said that was an accurate representation wasn't in the minutes, so that's been added.
Okay, so matters arising, members then.
Chair, just before you go off the minutes,
yes,
can I raise a couple of things? Page 4, number 8, regarding just want to commend the clerk for the good list of outstanding items that you captured regarding what they agreed to come back to us on the department and give us further update. Can I just ask us if we received any of that, if we received a response regarding any of the outstanding information yet?
No, not yet. No.
Would that come in the table pack in future?
We've committed that anything like that will be supplied. Okay.
And
Okay. So
item number 9.
okay.
If possible, Chair, inquire into gaps in equality legislation. The Women's Rights Network has reached out to say they haven't got any correspondence yet about the upcoming event, just to make sure that that's on its way, if it hasn't already been sent.
Okay, so matters arising, members, I would refer you to page 16 of the pack for a list of questions from Professor Patricia Lundy and Patrick Corrigan regarding historical institutional abuse following the Chair's my meeting last week with victims and survivors of historical childhood abuse. And I see that Jerry is in the gallery today. You're very welcome, Jerry. So just to remind members that the committee did write to the Department of Justice in April and to the PPS and PSNI in May for information on convictions related to historical institutional abuse. All 3 bodies replied to say that they did not hold up such information, and it is requested that this list of questions in the pack are forwarded to the Justice Minister to ask with the Chief Constable. And just for openness, I have also asked our representative Peter McReynolds, who's a member of the Policing Board, to also ask those questions. So others are entitled to do that if they also. But we as a committee, if we can go through the Justice Minister to the Chief Constable. Go ahead.
Could you just repeat who we wrote to previously?
We wrote to the Department of Justice. We PPS in that was April, and PPS and PSNI in May.
Have we ever wrote to the inquiry itself?
The inquiry's over. You talking about the historical institutional?
Yeah.
The inquiry, so was that 2017 or 2020?
Yeah, it's closed.
Closed.
That's my understanding.
Yeah. Okay, so and then also seek agreement. Then we would forward those questions ourselves that have been supplied by Patricia and Patrick Corrigan to PPS and PSNI as well. Okay. Okay, so thank you. We're now on to item 6 of the agenda in terms of historical institutional abuse independent facilitator. We're going to take some oral evidence. Members, page 18 of your pack, you'll find the clerk's brief. Page 20, a briefing paper, and page 12 of the table pack, you'll find some questions from the HIA stakeholders. Okay, so just for your information, this will be recorded by Hansard. Not all evidence sessions are, but just for the purposes of this session. So if you'd like to go ahead. We've got Paul Sweeney, the independent facilitator, and Patrick Gallagher, who's the Director of Victims and Survivors Division at the Executive Office. So thank you very much, gentlemen, for joining us today.
Thank you, Chair. I'll start and then I'll pass
it
to Paul for some opening comments.
Thank you.
So thank you to the committee. Firstly, I'd like to recognise the importance of financial contributions from institutions to victims and survivors. You know, we know that while no amount of money can take away the abuse they suffered, progress and contributions is seen by many as an important element of accountability. We are aware that the committee had a number of questions in last week's session with the Finance Director, so I thought I might start with an overview of where they are, try and pick some of those up, and then I'll hand to Paul to talk over his approach. So firstly, the committee will be aware that the Good Shepherd Sisters made a payment in April and a further payment in July. Payments were also received from Barnardo's in August and the De La Salle order in September. And then a voluntary contribution was received recently from the Diocese of Down and Connor, specifically in respect of De La Salle run homes. And we welcome the engagement with these 3 institutions to date and their willingness to be proactive about making a contribution. Discussions on appropriate contributions from the Sisters of Nazareth, the Sisters of St. Louis and the Irish Church Missions are ongoing. Some have indicated that they are committed to making a payment but wish to do so once the final figure is available after the Redress Board has determined all applications. These are sensitive and detailed negotiations, and it is important that there is space and time for them to continue in a constructive manner. Ministers are committed to publishing the details of payments once the process has concluded. Negotiations will not stop at the closure of the redress scheme on the 2nd of April 2025, as the final total of redress payments will be needed to calculate overall contributions from the institutions, and this will depend on how quickly or how many applications the board receives in this last few months and how quickly they can be determined. So last week the committee asked a couple of questions around what might be expected to be received from the institutions in total. The committee will appreciate that I can't get into the detail while negotiations are ongoing. It's important also to caveat this by noting that the Redress Board determinations, they aren't disaggregated between each relevant institution in situations where an individual suffered abuse in more than one place. So any figures or analysis is something that we have developed for the purposes of our discussions with the institutions and is not the product of an official report from the board. With that said, it is important to recognise that of the awards made to date, from our analysis, we have identified that approximately 60% of the awards relate to abuse in institutions that were solely the responsibility of the state. For example, juvenile justice centres, prisons, hospitals and state-run children's homes. So that's 60% of the total awards, representing approximately 50% of the money that has been paid to date. The state therefore continues to cover 100% of the redress payments in these cases, as the state had full responsibility for the care of children in those institutions. The committee will also be aware that HART investigated 22 homes and currently awards have been made in respect of over 100 homes. 6 institutions were found by HART to have had systemic failings. Now, those 6, I think it was 11 homes in total in those 6. So contributions are only being sought from those 6 institutions as per the recommendation from Sir Anthony HART. There have therefore been awards made in respect of some individual non-state institutions where we are not pursuing contributions, as there is no basis to do so. That means that the maximum amount that is in the conversation around contributions is less than 50% of the total paid and redress to date, and that is before taking into account the responsibility the state had and the failings found by HART in respect of those voluntary institutions, those 6 voluntary institutions, including the failure to undertake inspections and shortages in funding those institutions. So Paul can say a bit more about how he factored that into the development of his framework. In addition, HART acknowledged that in negotiations, institutions may wish to argue that their funds or their other obligations are such that they are not in a position to make such a contribution, or in the case of institutions that have already made payments, that the payments or other outlays such as travel costs from Australia should be taken into account and set off against any contribution to which they may be asked to make, so that they do not pay twice over for their failings. So I appreciate that this is not the full detail that will be provided once the process is concluded, but I hope this has been useful in helping the committee understand the scope of the discussions. So thank you for the opportunity to make some opening remarks, and I'll pass to Paul about his framework.
Thank you.
Thank you. Thank you, Chair. Well, members, I was going to outline the way in which I approached this task of trying to seek an agreement on a fair and proportionate contribution from the 6 institutions. So I have a presentation here, but if you want to stop me at any stage, or if you prefer, I'll go through the presentation.
Sorry, just before you start, is there any way that could be emailed to us? Your
No,
presentation?
it's just my own personal
Okay.
notes.
Okay, go on ahead. If it goes
Thank
on
you.
too long, we'll try and curtail it. Thank you.
Well, I was appointed in July 2021. I gather the idea of appointing an independent facilitator was suggested by Archbishop Eamon Martin, so I thought that was interesting. I suppose it's worth making clear that I'm not an advocate for the institutions. I'm not an advocate for the victims and survivors, and nor am I an advocate for the executive. I'm a truly independent facilitator trying to seek an agreement. As you might expect, I've met with the institutions, all 6 of them, on a number of occasions, engaged with the Commissioner on a number of occasions, and I thought it was very important to reach out from day one to meet with the various representative groups of the victims and survivors. And I've met with, I understand there's 6 groups in total, there may be more, but I've met with 5 of those groups, and I've sought to keep the victims and survivors representative groups informed as the process unfolded. I think at the outset I should say that the 6 institutions have fully engaged in the process and have approached it with good faith. From their point of view, they are keen to reach an agreement on a fair and proportionate contribution. Justice Hart was clear that if we couldn't reach an agreement, the process would go to mediation. Mm-hmm. And if mediation couldn't resolve matters, it would go to binding arbitration. And that's just like where you bring in lawyers and pay them loads of money. So this process is trying to seek an agreement that might avoid the need to go down that route of mediation and ultimately perhaps binding arbitration. The institutions understand that it's in everybody's best interest to resolve these matters. There's at the heart of this is a degree of atonement, a degree of accountability, and I'm very reluctant to use the term closure. I don't think you ever get closure on these matters, but certainly to bring it to some honourable resolution. Of course, Justice Hart, who did a terrific job, nevertheless didn't define how one would go about determining what a fair and proportionate contribution might be. So there's no formula, legal or moral, for calculating what a fair and proportionate contribution might be. And indeed, the legislation that took forward this process, the Historical Institutional Abuse NI Act 2019, again makes no provision in terms of contributions, and certainly no methodology for assessing what a fair and proportionate contribution might be. So just to acknowledge, these matters are very, very sensitive and complex and very nuanced. Because at the heart of it really is, what was the degree of culpability on the part of the state? And what was the degree of culpability on the part of the institutions? So that really was the kind of, at the heart of this, where I sought to focus the discussions. And what you're trying to do here is balance a number of competing considerations. And frankly, where you land on that depends who you talk to and what people's lived experiences might be. As the independent facilitator, I was able to call upon legal advice from a firm of solicitors, who in turn retained on my behalf a senior counsel's advice. So it was important that I didn't rely upon, if you like, DSO, the government legal advice. So I was able to access senior counsel advice on these matters. And broadly speaking, the brief that I put to the senior counsel covered 3 areas. I asked the senior counsel that, based on domestic and international law and drawing on the experience of similar redress schemes, particularly the redress scheme in the Republic of Ireland and the redress scheme in Scotland in terms of proximity. So based on domestic and international law, is there a legal construct that I can apply to this process that would determine a fair and proportionate contribution? Second question was, is there a legal basis or precedent for seeking a contribution from the parent bodies of the institutions, in this case the Catholic Church and the Church of Ireland? And I suppose the third part of the brief was, what legal levers might be available to the Northern Ireland Executive to compel institutions to make a financial contribution?
Sorry, could you repeat that last line? Sorry.
The third one was, what legal levers might be available to the Northern Ireland Executive to compel institutions to make a financial contribution. So if you like, that was kind of my starter for 10 in terms of really getting some part of the jigsaw on which I may take these discussions forward. And what I was able to do after various discussions, I was able to compile what I have called a framework document. And indeed, earlier this year, with the restoration of devolution, the First and Deputy First Minister took the view that, in principle, the framework document, as I had drafted, could perform the basis whereby we could seek an agreement from the institutions for a fair and proportionate contribution. And as a result of that, officials led by Patrick have been able to get into what I call the more nitty-gritty discussions with the institutions, because we now have in place at least a broad framework within which we can move from the principles into the nitty-gritty of the negotiations.
Sorry, just before you go on, just so we can keep track of this, where are we up in the calendar at that stage when you've got that framework agreed and you start bringing in the TO officials?
Well, if devolution was restored, say, February of this year,
Okay.
I'm thinking I had the meeting with the First and Deputy First Minister. Was it April?
The meeting was in April. But we,
That's okay. That's
but-
okay.
okay.
Get my head around this.
But can I say just that we had been working on that basis before the executive came back, so we'd work on that in the absence of ministers, looking towards whether a decision would be made under the EF Act, and then with ministers came back, it wasn't necessary.
Sorry.
So there's a framework that could form the basis of reaching an agreement.
Mm-hmm.
The framework's in place, and if you like, there's a bit of a transition now where we're moving from the generality of the framework into the negotiations that Patrick's taken forward. I'm not directly involved in those negotiations, but I'm available to Patrick or to the institutions to be called in where it might be considered that I might have a helpful role to play. In terms of trying to land this, what is a fair and proportionate contribution? Given that there was no legal construct, and at the heart of this really is just a moral argument, really. And it's that issue about the culpability of the state versus the culpability of the institutions. Not unsurprisingly, given that legal context that I've set, I've suggested that there should be like a 50-50 contribution. So whatever determinations might be reached against specific institutions in terms of redress, that you would split the difference, that the institutions would be asked to make a contribution of up to 50% of those determinations against their respective organisations. So these are my ballpark figures, Chair, so I know this has been recorded in Hansard, so just treat this with a great deal of caution. But as members know, the scheme concludes in March next year, so it's a matter of months away. And of course, after March next year, I am assuming that the Redress Board will need some time to process any outstanding applications. But I'm going to say that in my view, and there's no real science behind this, it's my best estimate, and for the purposes of this afternoon, the whole scheme will probably come out at about £100 million in terms of payments. And as Patrick has said earlier, for the purpose of this conversation, the 6 institutions, you could allocate £50 million of that £100 million against the 6 institutions. And if you applied my 50-50, then you'd be asking the 6 institutions to make a contribution of up to £25 million. And what really is important here, if I now refer to Justice Hart's report, so we recommend that any voluntary institution found by the inquiry to have been guilty of systemic failings should be asked to make an appropriate financial contribution. But importantly, he went on to say that the amount and how it could be paid should be negotiated between the government and the institutions concerned in the first instance. And for example, institutions may wish to argue that their funds or their other obligations are such that they're not in a position to make such a contribution. So, members, it's useful to focus on this figure of perhaps the whole scheme landing at about 100 million, about 50 million of that being allocated towards the 6 institutions. And if my framework was to come to pass, the institutions would be asked to make a contribution of up to 25 million. But the nitty-gritty negotiations that's ongoing with the officials now is applying that paragraph, where the institutions may want to pray in the fact that they've paid out money to date, or they've got ongoing other obligations, or quite frankly, they're not in a position to make a contribution. So Justice Hart was quite clear on that. So that when Patrick says these issues are quite sensitive and ongoing, you'll understand that context. I wasn't going to dwell into the fact, and Patrick alluded to it, that in some instances a child may have attended more than one institution. Indeed, in some instances there was one case of a child being in 7 institutions and may not have experienced abuse in 6, but may have been horrendously abused in 1. So I'm not going to go into detail around all of that. And importantly, Justice Hart said that the institutions should be asked to make a contribution towards specialist support services. So again, I wasn't going to dwell into that just at the moment, but if members wish to go there, we could, of course.
I would appreciate if you would speak to that.
Okay.
Thank you.
I'm tempted maybe to pause there in terms of just making best use of your time. In terms of the contribution towards the specialist support services, I think it'll naturally flow later.
Okay.
But any questions around the logic of that framework?
So can we see the framework? Have you got it? You know, would we be able to see that?
No, Minister just said they'll publish it at the
Okay,
end when
okay.
it's included.
Okay. Okay, well, thank you both. I just wonder about the issue there of the fact, that's why I asked the timescale there around the engagement of the three orders, the Sisters of Nazareth, Sister of St. Louis and Irish Church Missions. They're all at different stages of discussion. Could you speak more to that, please? In terms of, is this a reluctance? Is it a finding the right person of civil authority to engage with?
No, I'll speak to that one because, as Paul said, it's got into the specifics. No, I think we've had good engagement and we are engaging with the right people across all three. As I said earlier, some of those have said that they're willing to make a contribution but want to wait till the end, which, in terms of financial planning for themselves, it's not making a commitment at this stage. I think one aspect that's relevant is, and that they may well be conscious of, some which would have had the same experience in the Republic of Ireland, is that there was an agreement based on estimates at the start, and then, the scheme mushroomed far beyond what anyone would have expected, and then there was a huge amount of recriminations and discussions around increasing those whenever one agreement had been made and suddenly that agreement was an increase was sought. So that's the approach we have taken, which is different, which is based on the actuals instead of the estimates. What we've tried to do then, and what we're welcome from the other three, is that we know that importance to victims of seeing the money up front, and while there may be a rationale to waiting to make a final payment right at the very end, having the money up front shows that accountability, and we've asked for those interim payments based on the framework and based on the actuals to date, and that's where we've got with the first three. But the fact that the other threes haven't come in doesn't mean that they've said they won't be making a payment when it's the figures are final, which could be sometime in late 2025, depending on how many applications come in.
Okay, so Paul, you used the term fair and balanced, fair and proportionate contribution quite a bit. Could you go into further detail around how you landed with 25%? And also, I would say not that I am a victim and survivor, but I think some of the terminology around that I think would be a wee bit too generous to those institutions that suffered abuse, that they would be afforded this sort of fair treatment whenever they didn't afford a fair treatment to the children who were in their care. So I just want you to speak to that, and also the legal levers you talk about in terms of compelling, whether that is something that is being looked at by the department. Thank you.
Okay. In terms of the legal advice, and indeed, again, Justice Hart drew this out in the inquiry. Ultimately, when all is said and done, the state was responsible for these children, and you can't get away from that principle. That's the core principle. They certainly delegated some of the responsibilities to the institutions, and indeed, just a quote from Justice Hart: "We consider that the government departments had an overarching and ultimate responsibility to ensure that the authorities to whom it delegated functions undertook them in a responsible and effective manner." So, in terms of the legalities of all of this, when all is said and done, the state has the ultimate responsibility. So try as I might to try and get some kind of legal construct that could ascertain state culpability versus institutional culpability, there was no legal formula that the senior counsel could land for me. So in situations like that, and it's not about a pound of flesh here, but in situations like that, the test of reasonableness would be that you landed on a 50-50 contribution. So really, there's not much more legal or moral construct around that I can offer you, Chair. That's really how I landed this. I had in mind that the Republic of Ireland scheme was predicated on that 50-50 contribution. The Scottish scheme is different because there was a much more pronounced role for local government there. So they went 1/3 central government, 1/3 local government, and 1/3 institutions.
Okay.
Can I just come in there, Chair? Around, just for clarify around the 25%, so maybe 25% of the total, but it is 50% of what the institutions, because as I said, 50% is not in the conversation because the state has solely accepted responsibility for that element that the state had responsibility for.
Okay, and the legal levers, I suppose from my point of view, I think that if we don't see the religious orders institutions stepping up in this space, then I think that we should, as a public authority, bring in the legislation that would compel them to make those contributions. And I'm just wondering, can you speak to the conversations you had around that?
Yes. I mean, in terms of due process, if this attempt to get an agreement based on that framework that I've just outlined, if it fails, and it may not fail in all 6 cases, and Patrick and his colleagues have made very good progress on a number of fronts. So it might be that it might only fail in 1 or 2 cases, but Justice Hart was clear that in terms of due process, a failure to reach a voluntary agreement would then move on to mediation, which is say could be expensive, and thereafter it could go on to binding arbitration. So presumably, and I want to show great respect in the company of legislators here, but presumably, you wouldn't consider the legislative route until those other processes have been exhausted. But even if you went down that route, and obviously the legal advice that was provided to me was provided, under privilege, right? But the general thrust of it was, tread carefully in terms of the legal levers that might be available, even to sort of go down that kind of civil law route, or perhaps even legislative route. Now, I think you as legislators are well placed to kind of scope out that field, but based on the senior counsel advice that I received, it may well be that the room to manoeuvre there is quite limited.
Okay. Loads of more questions, but I'm conscious that this is an area we are all very interested in, so I'll come back in if they aren't asked. Deputy Chair Stewart, would you like to ask some questions? Thank you.
Yes, Chair, thank you very much, and apologies for not being there in person today. Can I ask just probably a general question, but I think an important one? How satisfied are you that the various institutions that will be required to provide money actually have the resources and funds to pay?
I think that's something that, as Paul has alluded to, comes under the specifics that when we were working through the paragraph that Hart put out, looking at contributions already made, wider obligations, then affordability as well is a factor. So it's certainly something that we can take advice on, and we're looking at the due diligence and requesting accounts, scrutinising those accounts in detail. Obviously we have access to financial support if needed. So it's something that we're very aware of, that is an essential part of the process. But maybe just not to get into the specifics of each of the 6 at this stage.
Do you hear that okay, Stuart?
Yes, that's been very helpful. But and I'm pleased to hear that there is due diligence being performed in terms of the assets and the resources of the various institutions. But certainly, first and foremost, must come those who have to be compensated, even if that is to cause irreparable financial damage to the institutions. Are you prepared to go as far as that?
But I think that what the approach we've been taking, the approach that Paul has taken, and the approach all along has been based on Sir Anthony Hart's approach, which recognised obligations that institutions have and their level of affordability, also recognising some of the knock-on impacts there would be, for example, where there are nursing homes or other services that are provided that would have a knock-on impact, one on those individuals who currently avail those services, but equally would have an impact on the state in sourcing replacements. So there's a lot to take into account to make sure that these negotiations are sticking as close to what was recommended by Hart, and are making sure that there are no wider consequences of them that impact on citizens.
Thank you, Chair. That's been very helpful.
Thank you, Stuart. Sinead, please.
Thanks, Chair. And thank you for the update, and just even laying out that methodology is really important for us as well to get an insight about the work that you've been doing since 2021. What has been the most challenging part of that work, Paul?
I suppose really just meeting with the groups that represent the victims and survivors, really, you know. I mean, it's just so very, very raw still for them. And, you know, I said earlier I didn't want to talk about closure because I don't think there is any closure on this. You know, I think whatever you experienced in that childhood, I think it's true of all of us, you take to the grave, you know. So I think it was challenging, and there was a wide spectrum of views, you know, among the people I met. I mean, and by the way, out of what probably will be about 6,000 cases, you know, let me just put this in context, Chair. I've probably met less than a dozen people. So I don't want to give the impression that I've sort of engaged with the whole cohort or an even representative group of cohort of victims and survivors, but I've met with people who have passionately committed, you know, to be advocates in this field. And, you know, some of them say, look, you really have to go after these institutions. And if you can't get it off the institutions, go after the parent bodies, you know, go after the Catholic Church, go after the Church of Ireland, you know, make these people pay. They're asset rich, you know. And really, you know, I'll not be able to kind of get any sense of closure until you really do that. And then at the other end of the spectrum, people are sort of saying, look, can we just get some kind of honourable soft landing for this process here, where we can, you know, move on. So that was very, very challenging. And I suppose at the heart of that spectrum, that's where I kind of landed the 50-50, you know. I don't think there's going to be a golden moment here where people can say, brilliant, this is all sorted. You know, I think we're, like life, we're looking to kind of land us in an honourable, compromised position.
I would say, Paul, I really don't like the phraseology, even honourable, because there was nothing honourable in any of it. And even as contributions will be made and redress will be made, I don't think there's going to be a great feel-good factor anywhere in this piece. And I suppose we have, as a committee, talked to loads of victims and they've made representations here. And what I hear is from them, not universally, but that the institutions abused them, the places where they lived and the people that were meant to look after them failed them. And I don't know whether they'll see a 50-50 resolution as something that is fair. But again, we'll talk to the groups again and have those discussions. What I want to see happen is that contributions are made by all of the institutions, and I just think that even at this stage, the fact that they're waiting to see is dishonourable in that very. In the very way that they're waiting to see what others or what the data sets are going to look like, and they've been reluctant to give us figures and numbers and all of that. It's been very difficult the whole way along. So my consideration is that the people need redress and they need it, they need it soon as possible. Everybody's getting older. Time is moving on. And they want to see it in their lifetime. And I'm just concerned that we're still in the process of some of these institutions sitting with their cigars and saying, well, wait and see. That's how it comes across to me. Well, it's a game, and it's not a game. They need to be fair. And they need to do the right thing. So that's all I'm saying. There's nothing really else that we can say here.
Okay, thank you. Brian, please.
Thank you, Chair, and thank you, Paul, for your work on this and your presentation today. I found it very helpful. And also, Patrick, the work you're involved in. I think for us all, can you just confirm, first of all, that the actual redress payments to victims and survivors aren't depending on the amounts paid for the institutions? That has been paid effectively by the state in anticipation of the money coming in, and also recognising the culpability of the state, as you've said. So I see you're nodding.
Confirm it.
Yeah. So at least victims and survivors aren't waiting on that money coming in. I might have misheard you, Paul. Did you say you'd met with 5 of the 6 institutions? But you also, in your notes, you're saying that they're all engaging. So
No, sorry. I understand there's at least 6 representative groups of victims and survivors.
right.
I've met with 5 of the 6,
Okay,
but I've
maybe I
met with
was-
all 6 of the institutions, the religious institutions.
Okay, you've met all 6, and
Yeah,
perhaps
yeah.
I was right. I
No, no,
missed.
sorry. Yeah.
You were talking about the survivor groups,
Yeah, yeah,
right? That's
yeah.
fine. You've met with all 6
Yeah,
institutions.
yeah, on a
and
number of occasions.
yes, no, that's fine. There's none is resisting.
No.
We're hoping to get them all before us, but they're all engaging with you because that's what your notes say. And in terms, at least I acknowledge that you've put something on the table in terms of a formula, and because we can all talk about it, but at least you're suggesting one there is 50-50. Who decides on that, and can we end up with some consistency? Because I note there, Good Shepherd Sisters have made payments twice based on the actual payments out. Bernardo's have paid once, De La Salle have made a payment, and Down and Connor in recognition of their role. Who will decide that? Is that ultimately the department?
So those payments that have been made are, we're calling them interim payments. They're, the first payment that is in, that is a percentage of what the final payment will be, because we cannot know what the final payment will be until the figures have been finalised. So that's a payment set over a certain amount of time, a certain amount of awards, and so we will apply the framework and pay X percent of that at this stage. So those will be almost, the balance then will be sought at the end once we know what the final figures are. And that's why we've taken that approach of trying to get interim payments in rather than waiting to the end and seeking 6 single lump sums. We've tried to take that interim approach to show that dedication to the process, that engagement and that accountability, because, as members have said, that's what the victims and survivors want to see. So even though it's imperfect and we will by necessity have to go back for a second payment, the institutions the 3 that have paid all have understood that and have committed that this is an interim payment, and we will keep the negotiations going, we'll keep providing the data sets, and when this is finished then we'll continue those for final payments.
Well, can you say, or perhaps you're saying it's part of the confidential process, but can you say that the payments that have been made based on what has been paid out in redress, has that been based on a 50-50 basis?
So those payments are based on at a point in time. We've taken a set point in time to look at and made an offer of an interim payment, reflecting that that's not the full process. So we'll have 5 full years plus then however many months need to finish off the applications after 2nd of April when the scheme closes the applications. So that's only up to a point in time. There are continuing to be applications submitted, continuing to be applications determined, and payments continue to be made. And every time those are made, that's another one added into the ledger, so to speak, that we will be going back on once it's closed to seek a final settlement.
Okay, I'm not sure if you answered my question, but anyway, are you aiming though for a consistency of approach across the 6 institutions? I know there's some, obviously, circumstances will vary, but are you aiming to have a consistent formula?
Sorry, apologies
that is
if I
applied?
didn't answer that. Right. Yes, so if we're applying Paul's framework, which is a consistent approach across all 6. So initially, whenever Paul had engaged to develop the framework, and then the department started to engage, we would have had all 6 meetings, within a couple of days of each other to make sure it was a very consistent approach. We were treating the institutions the same, saying the same thing, and applying that consistency. But it has diverged since because of the individual circumstances and because of sticking to the HART recommendation around the different individual circumstances, obligations and affordability. So the intention certainly in the framework is the same. It isn't adapted for each 6, but how the outworking of that ends up will be dependent on the individual circumstances
Of
each individual
the
institution.
institutions.
Yeah. So we're aiming for the
You're
same.
talking about their financial circumstances?
With their financial circumstances, their obligations, payments that they have made already, that HART had recommended be taken into account so that they're not paying twice over. So those all differ across the 6 institutions, and then that will lead to a different outcome. Perhaps for some it may not do, but the intended aim is, as per Paul's framework, the same across all 6.
Mm-hmm. Yeah, my concern is that some institutions will say, you know, it's like people setting up different companies and saying, oh, only liability is only with this one small company, even though it's part of a much wider organisation and network. And quite frankly, there is, within that network, there's the ability to make the compensation payment, you know.
That's certainly something we're aware of, and that we, you know, when we're looking at the financial figures, these are mostly registered charities, so accounts are available online, so we can see very clearly what accounts are held, for example, in Great Britain, what accounts are held in the Republic of Ireland, and can look at the wider picture and not just where they are registered or where they have premises in Northern Ireland.
Okay, thank you.
Thank you. Timothy, please.
Thank you very much, Chair. Thank you very much for your presentation here today. Paul, what has struck me is how respectful you appear to be to the institutions. This whole inquiry is because of fundamental failures. Would you agree with that? That's the reason of this inquiry?
Well, as I said earlier, I'm not an advocate for either the institutions, the victims and survivors, or even the Northern Ireland Executive. I'm trying to get some kind of like what strikes me. I mean, the gambit of the inquiry was from 1922, from the formation of the Northern Ireland State, right up to 1995. So, like, shockingly, like, it's 30 years on since the last case really, you know, crystallised. Like, it's amazing just the passage of time. No, I mean, I at the start of the process, I just embedded myself in all the kind of evidence that Justice Hart and the inquiry. I come back to this point, really, that, you know, ultimately the state was responsible within the institutions. Anything from a hostile environment right through to, you know, the most horrendous examples of abuse took place. But, you know, if there was light touch regulatory regimes, very infrequent inspections, arguably, you know, quite low levels of state intervention. So Justice Hart was trying to be fairly all that sort of context. So that's why I've kind of remained very neutral in all of this. I am struck by the fact that the people who are now taking this forward largely weren't people that were directly involved. As I say, it's 30 years since the last case, if you like, crystallised. And so the people who are now, if you like, leading on behalf of the institutions are genuinely, I use the term honourable, they're generally trying to do the right thing now, really, for the process. And yes, they have a fiduciary responsibility towards their own organisation as well.
You can see it from our point of view, where we're tasked as a committee to look at this issue, and there's a number of the institutions won't even come and appear before us, which gives me the impression that they're not facing up to their responsibilities. Yes, you've engaged with them, but they're basically, you know, stonewalling this committee. That's something that concerns me. It concerns me how soft, it's a softly approach it appears you're taking. Do you know how many people have died between the publication of the Hart report and of today that would be classed as victims or are victims?
I mean, the short answer to the last question there is absolutely not, right? I wouldn't even attempt to speculate. But the idea of coming before the committee, I mean, again, I don't advocate for any three of the component parts of this, really, but I suppose if I was giving advice to the committee, you know, I think we've reached the delicate stage in all of this, you know. I think the independent facilitator process has largely taken its course, so I was acting on behalf of the Northern Ireland Executive. The nitty-gritty negotiations are taking place now with Patrick and his colleagues with the institutions. Ministers have made it very, very clear, look, when the music stops, there has to be complete openness and transparency about where this lands. So there's not going to be some kind of shady deal somewhere that, you know, in a corner. Everything has to, you know, ultimately, you know, be completely on the public record, whatever the outcomes might be. But I'm not sure, if I'm saying this very respectfully, Chair, right? I'm not sure what added value the committee might bring at this stage.
Well, with your indulgence, Timothy, when we took evidence from the Northwest survivors, They said that the institutions were put on notice in 2010 that they were going to have to make a contribution. I think we're frustrated on their behalf that 14 years later, only 3 of them have come on board in the last few months. So that's where a lot of this comes from. Sorry, Timothy, go ahead.
Yeah, no, absolutely, and agree with your point. It's very valid. You had mentioned about the 73-year period from 1922 to 1995. Can you provide, why was the cut-off 1995, just for my own knowledge?
I don't know the answer to that, do you, Patrick? No?
Not sure, no.
No idea.
That's grand. If
Yeah.
we're,
I think there was a change in...
closed down. 96, the last one closed, I think. They closed.
moving on, in our briefing paper, contributions from institutions, there's a line in it where it says, were identified by the report as being required to make contributions towards the cost of the redress scheme and specialist support services. Is there a legal duty on them to make contributions?
No, there's not, and apologies if that's in our briefing paper. That might be loose word, and it's recommended. Should have been recommended by the inquiry, as Paula said earlier. There is no legal requirement, but there's a recommendation under HART. That was attempting to differentiate between the 6 that HART has identified systemic failings and those other ones where systemic failings were not identified.
So if some of the, well, 3 of the 6 have paid money, but if the other 3 turn around and say, we're not engaging, where do we go from there?
First of all, as I said, the 3 are engaging, and we've been engaging, and some have committed to making payments at the end. To go, if there is a refusal, which at the minute we aren't seeing, if there's a refusal, as Paula said, there is submitting issues to mediation, and then to binding arbitration would be the rule set out by Sir Anthony Hart. We also
There's no legal route to go down that, is there?
No.
Which concerns me. I suppose moving on, so you mentioned, for talk's sake, 100 million in payments, and you have said about the 6 institutions, up to 25 million each. So if there's 100 million
total.
25 million total.
in total. So 100 million payments. How much is this inquiry, and its totality costing? So when you're talking about the 50-50, is it 50-50 purely on what's been paid out, or is it 50-50 in the total cost of the inquiry? So the likes of, the payments towards yourself and the work you're doing, the payments for running this redress scheme, or is it just 50% of the payments to the victim?
For the purposes of the framework, it's solely on the basis of payments. So I'm using the term 100 million to represent the determinations by the redress board, and you've heard from the justice, who's the president at the moment. You've heard evidence from. So I have not included the, if you like, the cost of the infrastructural costs, right through from the inquiry, right through to the cost of the redress board, the cost of the commissioner, the civil service time and effort has been put into this. And that money would run into tens of millions of pounds. Okay, that has not been factored into the framework. The only consideration in the framework is the actual determinations that either have been made or will be made. And I'm suggesting that when the scheme ends, that'll probably be in the ballpark of a £100 million of payments, but does not reflect the costs, what I call the infrastructural cost of all of this.
Comparing that to the Republic of Ireland scheme, did they solely look at the cost of the payments when they were considering the 50-50?
I'm going to say I don't know, okay, because I genuinely don't. I was going to speculate that theirs was based on the payments only, but I wouldn't want to be categoric about that, nor could I be categoric about the Scottish model either. But again, I'm going to speculate that the Scottish scheme did not factor in the cost of the infrastructure. It was based on payments, and indeed they discounted the first 10,000 of each payment. So no scheme is completely comparable. But certainly for the framework purposes, I have not factored in the infrastructural costs of redress because rightly or wrongly I've taken the view that that has been the primary lead of government, and the government has taken this process forward.
Last week we had the monitoring round and we had figures brought to us and what was envisaged would come in, and that's the money that counted into the end year. Is it yourself provides the figures of a timeline of when the money's coming and how much to expect?
That would be me as a departmental official. So we would work closely with the finance team to factor that into the submissions on the monitoring round and the decisions on budget, because we have an agreement from DOF that can be used within TEO. So that's something that we would work on to make sure that it's factored in. But obviously the specific details is something that, given it's a live, sensitive negotiation, the ministers do not want to release at this stage, but will release when the process is concluded.
Yeah, and just come back to the progress and contributions to specialist support services. So can you tell us a wee bit more of where we are? And we've talked about the 50-50 regarding the payments out the other end. There'll be a supporting process needed for victims as they progress through life. Is there payments being made towards specialist services there?
Well, I'll mention the framework and then maybe defer to Patrick. So, as I said to the Chair earlier on, maybe we could return to this, because Justice Hart specified that there should be a contribution towards the cost of specialist support services. So again, in terms of money, the scale of what we're talking about here is much more reduced, right? And Patrick can go into the specifics. But again, I've suggested in terms of a contribution towards the cost of specialist support services, that should be approached on the basis of a 50-50 contribution as well. So in terms of a person who maybe attended an institution in the past, who is now seeking support, specialist support, that the cost of that support should be split on a 50-50 basis, 50% by government and 50% by the institution. But perhaps Patrick could put a bit more detail on that.
Yep, so we've said about Hart's recommendation around contributions would be a contribution to redress and to the specialist support services recommended by the inquiry. So as the committee will know, VSS provides services to victims and survivors of historical institutional abuse, have done so since December 2020, and the inquiry recommended that should be for a fixed period of 10 years with a review after 5 years. So there will be a review of that sometime within 2025, with the 5 years being up in December 25. That is something that, as Paula said, is in the framework, is factored in. Now, the costs of those is proportionally much less than the redress. If we're taking a round figure of approximately 100 million by the end of redress, there's approximately £1 million a year being spent on HIA services. Obviously VSS's wider budget is much bigger than that, so that would lead you to a cost of approximately 10 million. That is a factor in the discussions we're having with institutions at the minute.
Sorry, one of the committee staff has got to investigate. Apologies, it can be very distracting when that happens. Can I just come in on that question? When the clerk and I met with some groups last week, they said that 10 years really isn't going to be long enough in terms of the lifelong trauma and mental anguish, etc., that they are now living with as a result of that. The Hart's stipulation for 10 years is just a recommendation. So there'll be the review after 5 years. Is there the potential then after 10 years, for example, to continue that? I just think that it sounds like quite a blunt ending to say 10 years everybody will be fixed and all. No,
certainly that's not what I intended to say. I was saying that's what the initial view is. We have a business case cover for 10 years with a review to come up. Okay. Certainly that decision will be made further down the line, whether there needs to be an extension at that stage based on needs.
I think that's reassuring.
Just one final. When this was being set up, my predecessor tried to bring an amendment that would have brought in clerical abuse as well. Throughout your work to date, I would have concerns that people are being missed and falling through the cracks when it's very narrow to institutional abuse. Can you just give some comment of what's your findings in that to date regarding victims of clerical abuse and in foster care?
On foster care, I can't answer, but clerical abuse is something that comes under my responsibility as well. I know I'll be back at committee in the 11th of December with the independent chair of the working group specifically on the issue of clerical abuse.
It's in the Forward Work programme, so it's coming up. Okay. Emma, please.
Thanks, Chair, and thanks to you both for coming before us this afternoon and for answering the questions. So I suppose a lot of what I wanted to ask you about has already been covered, and it's just that same sort of, I was sort of struck, Paul, by your comments that you felt that the institutions were really engaging, and I suppose the questions that have been laid by other members, it sort of sounds counterintuitive that they're really engaging and then 3 of them haven't made any contributions, and there is a lot of anxiety there. And we've heard from the representatives of the victims and survivors that they don't want that the burden of the cost of support services is coming wholly from the state. They want the institutions to pay their fair amount as laid out by HEART. And I suppose there's a wee bit of incredulity around, you know, that there's a commitment there, because it has been 14 years been talked about, and we haven't made any progress. Aside from that, I just wanted to ask then about the memorial and where TEO is on that. I know that the groups had asked for a working group on that and to have buy-in to that process, and that the response we'd had before was that ministers were considering that. So I wanted to know if we have any progress there.
Yeah, so we've been continuing to work on the preparations that we can without having that decision yet on the way forward with the multiple different options put forward by the victims group. So we've been working with councils recently to try and have initial conversations around potential sites, but the decision on the final approach that we're going to take will be something that the ministers want to decide after having met with the victims group. So we've been engaging with private office to try and get those meetings held as soon as possible.
If I commented upon the contribution towards specialist support services, and as I said earlier, I'm not advocating for anybody here, but just to say, you know, part of the factor here is, you know, the institutions are asking themselves, well, where will we be in 10 years' time? And what if the specialist support services was to grow topsy-turvy? How can we make a commitment at this stage in the abstract? So I don't think it's unreasonable for them to kind of, you know, factor that into the way they're approaching this. So just to say that you know, that is a context within which this is taken forward.
Chair, I totally get that, and I appreciate your coming here in good faith and working with everybody as a mediation betwixt and between, and I get that, but I suppose it's kind of difficult to take that as a valid view from people who have inflicted so much pain on so many people, and you know, where they're going to be in 10 years' time is as a result of their own actions. And I would say you'd be hard pressed to find very many of them in society with much sympathy for them. So I take on board what you're saying, but I think the priority needs to be that they fulfil their obligation and their commitment in supporting those who have suffered at their hands. Thanks.
I want to come back to the memorial, but Claire, go ahead.
Thank you, Chair, and thank you for coming to committee today. It's really just to reinforce and pick up on a point that both the Chair and Timothy made around those who have not engaged with the committee and the purpose of that. I suppose you're engaging with them, and hopefully there will be success, for want of a better word, in relation to that. However, I think for the victims of all of this is about redress. So the money in itself will go some way in respect of that, but this is about ensuring that people are truly sorry for what had happened that shouldn't have happened. And I appreciate that there's time that has moved on, but those institutions still exist. So whilst they continue to exist, then they need to take responsibility, if you like. And, you know, I suppose given the length of time that has passed up until now, that trust is waning whilst this process still is ongoing. So certainly as a scrutiny committee of the department, but equally as representatives of people and of these victims, I think it's really important that we really do communicate that lack of confidence, that mistrust that this is going to go where it needs to go. And I do think there would be great value to those organisations coming before committee so that they can, I suppose, get the sense of gravity of what this ongoing process is doing. And I certainly think as leaders within Northern Ireland, it's pertinent of us for our own sense that we do hold them to account in the most senior way possible. So I don't think it will necessarily get in the way of those negotiations. If it does, I think that says more about them than it does this committee or any of the institutions that are there to represent and hold people to account. So I would certainly like to make the point, not necessarily to yourselves, but maybe people who are listening, that they need to move forward with this process if they genuinely want to be sorry for what they have done and take responsibility for that. So happy to hear a comment, or we can leave it there.
Okay, I just want to come back to the issue of the memorial. So it was my understanding, and I was trying to find it in Hansard there, but the Deputy First Minister, in response to, I think it was an oral or a topical question in the Chamber, said that they wouldn't be more moving forward with the memorial until she'd had herself and the First Minister had an opportunity to meet with the Victims and Survivors group. So this was probably, I think, around April time. She said that would happen before the summer. So the clerk and I met with 3 of the groups last week, plus Professor Patricia Lundy. They have written 3 times to the private office to ask for a meeting. So rather than the First Minister and Deputy First Minister being proactive and engaging, they are asking and have asked 3 times. So this whole issue of the memorial is just that they want to know, they want to move it forward, they want to be part of a steering group, they want to have full feed into what actually happens, and I think that they're being treated appallingly. What is happening?
Look, we understand the frustration of the groups that the meetings haven't happened, and that's something that we're continuing to press to try and get them into the diaries as soon as possible, because there's the memorial and a number of other issues that the ministers wanted to meet the groups about.
No. I mean, there couldn't be very many issues in the Executive Office that is more important than this. Okay. Anybody else got any? Oh, sorry, Sinead, please
just
come back in.
A short question. Are any of those organisations that you're engaging with, that are not engaging with us, citing an affordability problem? Are out of all 6, are the ones even that have paid money citing an affordability problem?
Well, it's something that, as Hart has recommended, that is something that can be taken up in the discussions, but would be a matter of the specific discussions between the department and the institutions.
Must be citing it already, but Patrick,
well,
I'm asking a direct question. Are any
of
the organisations saying they have difficulties with affordability?
Well, as I said, that's allowed for under the Hart recommendation. It's something that's part of the specific discussions that it's a live and sensitive area that we don't want to get into at this stage.
That's a yes, I would say then. Okay, thanks.
Timothy?
I'm certainly getting frustrated and have growing concerns about the willingness to go after some of these organisations. I'm certainly not getting it from you. 2 gentlemen sitting in front of me here today. You have said 50%. So if an organisation, an institution says, listen, we don't have the money, at what point do you then make the decision that 50% of the 100 million then will fall on to the other institutions? Or will you just simply be saying, you know what, that's their portion, we'll leave it to the side? At what point do you make that decision?
Well, in terms of the framework, if an institution either didn't make a substantial contribution or made no contribution at all,
the potential is 50%. That's what you're saying. Well,
the framework says, split it on 50-50. So just to go through the sums again, total sum 100 million, 50 million for the 60 institutions, and then you split that in 50-50, so 25 million across the 6 institutions. Okay. But if an institution or more than one institution failed to make any contribution whatsoever, right, that wouldn't penalise the other 5 or 4, right? That would be money that just wasn't received by government. So the formula is not set up that the others would be penalised if 1 or 2 or more institutions made either no contribution or a wholly inadequate contribution. Does that make sense? No?
And have you a hunger to go after the money?
Well, to be honest with you, I think I've discharged largely my role, was to sort of look at the kind of putting in place a reasonable framework based on senior council advice, based on experience of similar schemes in the Republic of Ireland and Scotland and elsewhere, right? And I think I've come up with a framework that isn't an unreasonable basis to seek agreement. If agreement can't be reached with either all 6 or 1 or 2 of them, then the option then is go to mediation. And that's, as I say, where you just get a whole bank of lawyers involved, right? Hugely expensive. And if that fails, then binding arbitration. So I'm not seeing any appetite on the part of any of the 6 institutions at this stage to kind of end up in a default position where we have to go to mediation or binding arbitration. I would hope that the good faith that I've seen to date will be able to get us into, I'm not going to use the term honourable position, but at least a position where the spirit of both Justice Hart and the spirit of the framework is fulfilled.
For many victims that are potentially watching this committee today, the money's immaterial. This is their only route to justice. And from watching, and I'll be honest, it's a la-di-da approach that I'm feeling from this side. You know, I want to see more pressing, more energy, and actually delivering justice here for people. And I'm simply not getting that.
Okay, what I'm going to draw this to a close. Thank you both for coming today. Thank you for your reports in advance, etc. Members, I'm going to suspend the meeting for a couple of minutes, and then when we come back we'll have a discussion then on what we feel should be the actions or anything following on from this. So for now we're just going to close the meeting for a couple of minutes. Thank you everyone.
Thank you, Chair.
Oh sorry, does the committee agree?
Yes.
And you'll understand why in a minute. You'll understand why in a minute.
Okay,
Thank you.
Thank you.
Committee Room 30, sound. 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 Committee Room 30, sound.
Okay. Welcome to those watching online. We're just resuming our meeting. So we're going to have a quick discussion on actions arising from that session and, you know, a decision about whether we write to the Executive Office, to the Department to seek more information, and if so, what information are we seeking? Does anybody have any initial views? Or I suppose that to start from the back and move forward, I think that we do need to press for the First and Deputy First Minister to meet with the groups to talk about the memorial project. If that's what's holding it up, I think that's what we need as a committee, to get behind those groups so that that engagement happens, to allow that to move forward. Any other suggestions? Or
we need a timescale for the contributions from the institutions.
Yes.
Just weren't given any timescale there, and with the redress scheme actually applications coming to a close. So there needs to be a target date, you know, a deadline for those contributions coming forward.
Okay.
And then the question about what is the remit for officials in terms of what the contributions are to cover? Is it only the redress contributions, or is it for support services? I'm not clear on that question. I mean, because that is a real cost, because yes, the state is bearing a cost and the state is culpable as well, but the institutions are very much culpable, you know. So the state, as questions were asked about the cost, and Timothy in particular asking about the cost of all these inquiries and all the infrastructure around it, the state is bearing that cost. Yeah. But if the institution's contribution is only based on the redress financial payments, should it not also, if it's based on the support for victims and survivors, should not be based also on those support services?
And that's stated very clearly. That was the intention, that they were supposed to cover that. Plus, I don't understand, like to Sinead's point about them saying about affordability, surely the Catholic Church should have, like,
they've got assets anyway.
Well, that was my point. Sorry to cut it, you know, about trying to limit it to one institution and its finances. I mean, it's part of a wider network. There certainly is the ability to pay, and okay, we'll see where it gets to, but we certainly won't tolerate any outcome where finances didn't exist within a certain institution, because there certainly is finance within the wider institution.
Go ahead, Claire.
I am a bit unsettled by the comment around the committee not having a role, because by extension then the department doesn't have a role, because we're the direct statutory script. You know, so I'm wondering what expectations are being set by the department, if that's what is being suggested from the independent facilitator. It might be worth getting that clarity from the department, because if they're involved in engagement and negotiations, then we're involved.
They're directly involved.
Absolutely. So, you know, I think we just need to make that clear, because, you know, to me what that did was undermine that whole session by suggesting that this committee doesn't have a role there, and we absolutely do, and very, very concerning, and the department maybe needs to be reminded of that as well.
Go ahead, Timothy. And then Sinead.
Sorry,
go ahead, Timothy.
I'm concerned that we're at the mercy of the independent facilitator. They have set the 50%. If we're relying on, you know, that approach to recoup this money, I certainly think that, you know, we'll be let down a bagful in that there's no legal emphasis for institutions to pay. I didn't see any fight today that somebody's actually going to go and make sure that we're getting the money. Like you have said, and that's why I asked, was there a hunger to go after it? So if somebody says, oh no, sorry, I don't have the money, assets, you know, victims don't have a choice here. Institutions shouldn't have a choice to shield and say, no, we can't pay.
But I think, just sorry, Sinead, before bringing you in, I think the issue, that was a recommendation of this. They ask for the money, then there's mediation, and there's the binding arbitration. That's a recommendation. This is a legislative body. You know, if it needs a law in place, as I think in the Republic they've brought in quite a few pieces of legislation. I think that's probably the way forward. Are you finished, Timothy? Or yeah. Sinead, please.
Probably it's just extending out just what Claire had said. This committee's not observers. You know, we're not here to kind of just observe things. We're here to actually ensure that the work is done by the executive office, but also to call to account those that are accountable.
Yes.
And so I, you know, to tell us that these things are at a very delicate point of negotiation now. So keep out of it,
exactly.
In case you upset the whole, you know, we don't know what contribution you could make. I think it's not probably an appropriate way to do it. And it actually, if the pressure is on, then let the pressure be on, because it needs to be. And again, the affordability, if I could go back to the affordability, I'm concerned that there is that has been, you know, that has been called into question by a number of the institutions, just by the very fact that there was a pause in the answer there. So that should give rise to concern to all of us at this particular point in time. And if organisations or institutions or organisations are waiting to the last minute to see, you know, what it all looks like before they make a commitment, then that's a point of concern too, and it's a point of concern now because we're aware of it. So therefore, I think that we need to have more transparency instead of saying, look, can't tell you much. You know, it's too confidential for you to be engorged.
You've kind of inspired a bit of a point there, Chair. So we're a legislature, we're legislators. And currently there's no legal framework to compel and all of that. However, as legislators we could potentially create that. Is there an exploration? And I don't want to preempt potentially negotiations, but is there a fact-finding exercise that we could do as a committee to fully realise the powers that we could have if things don't go the way they should?
Absolutely, and I suppose that was part of the reason why we asked for Hansard today. I think that, you know, and the fact that we are frustrated that we have written, the clerk and his team on behalf of us have written to the institutions and religious orders several times now and asked them to come before us. So I think we're moving towards that place. So I'm going to make a suggestion because we have a few other panels. So obviously we'll get the Hansard report, but I think if Clerk, if you can liaise with your colleagues, pick up if there's anything that we have missed in terms of our discussion as potential, circulate the letter that will go to the Executive Office so in case, and then we'll issue it. Is that okay?
Yeah.
I can clarify that now if you want. So
Oh,
it
yes,
was, it was
okay.
to write to First and Deputy First Minister to meet with victim and survivor groups. It was to write to the department to ask for a timescale for the contributions. Ask about the remit for the officials regarding, is it redress only or does it include support services and other things including the inquiry? To raise the concern that it was stated by officials that the committee doesn't have a role, and to reiterate the fact that the committee, that members believe we do have a role. And then does the committee want to add to that, if there is no legal route, whether the department would consider new legislation?
Okay. Okay, thank you so much.
Sorry,
Yes, go ahead, Brian.
can we ask, or has it been set out in terms of the contributions, are they based only on the redress payments, or are they also factoring in the cost of support services?
Okay, well, thank you so much, everyone. I think that was really useful today.
And over what time period?
Yes, the time period. Okay, so our next oral briefing session is from RAISE, so into historical institutional abuse. So the committee tasked the Assembly Research Service to undertake research on a general overview of processes in the Republic of Ireland related to various types of historic child abuse. So it's Thomas Luff. Is it for pronounced?
Yeah.
Research officer here. He's an Assembly member of staff. So thank you for your paper. It was excellent. I have to say it was very thorough, and I really appreciate the work you put into it. It was clearly a lot of effort. So do you want to speak to it a bit, and then I suppose that's good. We've got a presentation.
Yes. It's just a fairly just a couple of slides, partly so I don't stare at the paper the whole time, and also just to give a bit of an idea. So so thanks very much for having me today, and I hope the paper was helpful. It's obviously just provided an overview of some of the processes undertaken by the Irish government in response to historic institutional abuse in the Republic of Ireland. It summarises the processes that have already been undertaken, some that are ongoing, and some that are proposed in relation to 4 main areas. So that's mother and baby homes, the Magdalen laundries, residential institutional abuse, and abuse in religious schools. And there's also a couple of brief references of cases of abuse in other institutions which weren't so closely aligned with the state. It's not to be considered an exhaustive list of everything that's happened, but hopefully should give the committee an idea of the scope of the processes that are in place. So I won't repeat everything that I've put into the paper, but I'll just highlight some of the areas that might be of most interest. And if I'm happy to answer any further questions or attempt to anyway. It's worth mentioning as well, as I'm sure you'll be aware, but redress obviously isn't purely a financial process. There are other forms that can take. So we'll go through that. There's a previous Taoiseach have given public apologies on behalf of the state in relation to abuse suffered in mother and baby homes, Magdalen laundries, and abuse in residential institutions. There's obviously been a number of commissions of investigation, scoping reports, some legislative changes, memorialisation, and then obviously the financial redress schemes as well, which we'll go through some of those. The paper, there wasn't scope of the paper to go into a huge amount of detail on the financial redress schemes and how they kind of operate. If that's of interest, which it might be given the previous conversations, then if the committee would like, we can look into that certainly. But so this is just a replica of the table 2, which is I think on page 18 of my paper, which I'll go through. On that first one on mother and baby homes, it's just worth noting that the National Centre for Research and Remembrance that's been approved is not just in relation to mother and baby homes. That's for anyone who's resident in industrial schools, laundries, the mother and baby and county home institutions, reformatories and other related institutions. So it's a wider memorial there. So we'll begin with the mother and baby homes at the top. So the Irish Government established a Commission of Investigation in February 2015 to provide a complete account of what happened to vulnerable women and children in those homes from 1922 to 1998. And the final report was published in 2021. It focused on 2 of the most critical issues which were raised by former residents of the homes. That was the lack of information and tracing systems, and redress for the suffering caused. Following that report, the government published an action plan which set out full details of the full range of government responses. There's 22 actions in total and 8 themes. I'm not going to go into all of those, obviously, it's quite a few, but the actions range from immediate counselling support to financial support, a number of actions around education, and access to personal information and family tracing as well. Off the back of that, there have been some legislative changes. The Birth Information Tracing Act 2022, which gives a full and clear right of access to birth certificates, birth and early life information for people who are adopted and boarded out, and access to information by next of kin in certain circumstances as well. And also the Institutional Burials Act, which provides a lawful basis for full-scale forensic excavation, recovery and analysis of children's remains at the site of the former mother and baby institution in Chewham. And finally then, off of the back of that action plan, the Mother and Baby Institutions Payment Scheme Act 2023, which principally established that payment scheme, which would make payments and a form of enhanced medical card to defined groups to acknowledge the suffering that was experienced. That scheme opened in March this year. It's open to people who are in one of the specific institutions listed in the scheme, and there'll be 2 main groups of people. So for at least, if you're in one of those institutions for at least one night as a mother for reasons relating to their pregnancy or the birth or care of their child, or for at least 180 days as a child. And as I said, there's some health support payments and work related payments that applicants may be eligible for as well. I do have some numbers around applications and stuff on that, so if that's useful I can let you know, but I'll just...
I think what would be useful is the amounts, because obviously the consultation to the mother and baby inquiry, and the redress, because there's some dispute over the amounts. So just if you have any figures in terms of the compensate or the redress that...
Yeah, I don't have... there is a kind of long list of... It's worked out on how long somebody was in the institution for. I think the maximum payout is... I think it's €120,000. And the minimum, I think, is around 11,000. I'm happy to get those numbers.
Thank you.
But there have been 5,300 applications received by the end of October, and it opened in March. So that gives you an idea of the scale so far of that. But yeah, happy to get those numbers. In relation to the Magdalen laundries, there's been a number of reports in relation to those. So there was the McAleese report in 2013, which established the facts of state involvement. Approximately 10,000 women were known to have entered a laundry from the foundation of the state in 1922 until the closure of the last laundry in 1996. Following that report, the government then asked Mr. Justice Quirk to devise a scheme to address the needs of the women who were admitted to and worked in those laundries. The government accepted in principle all of those recommendations in the Quirk report, which included payment of an ex gratia lump sum. The payments made under that ex gratia scheme were between 11.5 and €100,000. And by January 2022, €32.8 million had been paid to 814 applicants through that scheme. There's then a wider residential institutional abuse processes. So there was a commission to inquire into child abuse in 2000. Following that, there was also an apology from the... just previous to that, there was an apology from the then Taoiseach, Bertie Ahern, and they established that commission. That report, the Ryan report, kind of outlined the extent of the abuse that took place, and made some recommendations, including establishment of the Residential Institutions Redress Board, the RIRB, and also the Education Finance Board, which was established a bit later in 2006. That provided financial assistance for training and education to former residents of specific institutions and their relatives, and there was a contribution of €12 million made by religious congregations towards that. That was dissolved and its remaining functions were transferred to the Residential Institutions Statutory Fund, Caranua, which I'll briefly mention later. So the Redress Board itself accepted applications from former residents of 139 reformatories, industrial schools and other relevant institutions which were subject to state regulation or inspection. Those applications were open until December 2005, barring some late applications. The final applications could be made up until 2011. They were awards made on 5 redress bands, and 85% of those were awards between bands 1 and 2, which allowed for awards up to €100,000. The average award was 62,250. As of 31st of December 2021, 16,663 applications were reviewed, with just over 50,500 resulting in an award. That redress board has now been wound down, so there won't be any further applications through that process. In terms of some of the funding, like I don't have specific kind of funding breakdown, but just to give you a rough idea of some of that. 2002, the government negotiated an indemnity agreement with 18 religious congregations. Under that agreement, they undertook to contribute €128 million in cash, property and other resources to the state. In return, the state agreed to indemnify the congregations against any claims made against them by survivors via the courts. There was a later, there was a further kind of negotiation on that, so that total was €245 million in total from the religious congregations. As I said, it's now been wound up, and in 2021, the government confirmed the overall expenditure for the scheme was in the order of €1.245 billion. So quite a large amount of money. There's been a lot of criticisms of that scheme, particularly that it was overly complex for survivors to access, very legalistic, adversarial, which was actually, it was designed to not be that way, and it was a traumatic process. It re-traumatized a lot of those survivors. And some felt they'd been pushed into taking settlements, and there was particular criticism around that indemnity, and they had to sign a waiver to say they would not take any civil action. Yeah. As I mentioned, there was also Karanua, which was the service name for the Residential Institutions Statutory Fund Board, established in 2013. That was a statutory body to provide support for survivors to improve lives and well-being. So that's around health, housing, and education. That was €110 million in the end, and that was funded by pledges from congregations who were responsible. That has now closed. That fund has now closed, and it's just awaiting further legislation to dissolve it as a body. And then finally, in relation to abuse in religious schools, you might be aware that earlier this year there was a report on the scoping inquiry into historic sexual abuse in day and boarding schools run by religious orders, which was led by Senior Counsel. Central to that work of the inquiry was engagement with survivors, which was led by a child protection expert and conducted by facilitators who were trained in trauma-informed practice. The report contained some recommendations for government, which were stemmed from key concerns that most of those participants were keen to see from the after it. So the primary recommendation in that was that the government establish a commission of investigation and a survivor engagement programme. It also proposed some terms of reference around that. The government just in September, accepted that recommendation and will establish a commission of investigation. They also recommended a redress scheme. There hasn't been any firm confirmation of the redress scheme, but it's something that certainly the Taoiseach has recently commented on that will be necessary. Obviously, with that and the dissolution of the Oireachtas, we'd have to wait and see what an incoming government would do. So I wouldn't want to comment on anything further, but that's certainly the commitments that have been made most recently around that. And then you'll see also finally that there's in the paper there's just some other institutions there, namely Scouting Ireland and St John Ambulance, who were both subject to allegations and also took some action to address that. So I think that's the majority of it. There is some further research at the end of the paper it's kind of quite hard to get prevalence kind of studies, and certainly the Oireachtas Library Service have said that there's no up-to-date data precisely on the number of survivors of abuse in residential institutions who are still alive today. So it's quite hard to put a number on some of these, but hopefully if there is some more information in there. And as I said, I'm happy to try and answer any questions, and if not, come back to you through the clerk at some of the point.
Thank you very much. It was an excellent paper. It was actually exceeded my expectations, because you really went delved into it. I suppose there's a few issues. First of all, they do seem to be very strong on legislating for access to birth records and adoption, so I think there's a bit of more work for us to be looking at in that. But in terms of your research, two questions. First of all, the Mother and Baby Institutions Payment Scheme, do we know whether that's just for people based in Republic of Ireland, or can people, for example, in America or Australia, can they apply to it?
Yeah, so you can apply if you don't live in the Republic of Ireland,
okay,
providing you went to one of the
okay,
institutions mentioned. The main difference in terms of what you would be entitled to through the scheme is around the enhanced medical card.
okay.
Obviously, that's not relevant if you're not in that jurisdiction, but there is a payment that you can avail of potentially if you're eligible for that instead. Yeah.
Okay, thank you. And the second one was, you talked about some of the schemes being wound up and dissolved, etc. And I suppose we know from survivors of historic abuse, sometimes it can take many years to disclose. And I'm just wondering, is there any mechanisms where people maybe 10 years after, are ready to, is there any mechanisms you came across where people could come forward for redress?
So there was obviously the RIRB, which was the larger scheme on residential institutional abuse, which closed 2005, but did leave it open under specific circumstances for late applications until 2011. But since that closed, there's no avenue through that. It's certainly, there is actually, and I reference it in that list at the end, but there was a consultation with survivors that the Irish government commissioned, which is really interesting, and that talks about some of the challenges that survivors have had, and one of those is that a lot of people didn't find out about that redress scheme until it was closed,
yeah,
or until past 2005, and they didn't fit the exceptions to extend their. So there were, the scheme itself, or the board itself, did do a lot in terms of advertising, both in the Republic of Ireland and across the islands, and also particularly in Australia and Canada, where there's obviously a large diaspora there. Some of that through newspaper, radio, that sort of thing, but it wasn't effective enough to reach and some of the survivors said actually they're aware of most people they're aware of were not able to avail of that scheme. So it's
that's where we're afraid of HIA and this one. I've got Brian and then Timothy. Go ahead, Brian.
Okay, thank you, Thomas, for the report and your presentation to committee. In terms of what was happening in Northern Ireland, the scale in the Republic of Ireland is even greater. 10,000 women entering Magdalen laundries over the 74 years that they operated. It is shocking to read some of the statistics. In terms of, I'm trying to pick out the information regarding what we've been told in our earlier presentation. In terms of how contributions, what formula was used, and was there consistency about it, and is that work ongoing with the institutions? Is it at a more advanced stage in the Republic of Ireland, or are negotiations still happening? We were told earlier that the Republic of Ireland was predicated on 50-50. Were you told that? Are you familiar with that as a suggestion from the research you've done in the South? And I've one other question.
Okay, no problem.
Go ahead.
Yeah, grand. Well, that wasn't something I'd come across, but I wasn't looking specifically in this paper for the kind of breakdown of the funding and who, whether they were able to get those donations. But I would say that the numbers that I have seen, so for example, that redress board for residential institutions, the total expenditure of that scheme, and that includes payments and also the running of the scheme, is almost 1.25 billion euros. So 1.245 was the number that the minister gave. The total that was contributed by...
Is that across all the schemes in this paper? Or
No, that was that one scheme.
Just which one?
The Residential Institutions Redress scheme.
The one as we're talking about, the 100.
So the numbers in the other scheme that we have numbers for in the Magdalen Laundries is a lot less. That's around 30 million. But this one's obviously a large number. In terms of what was contributed by the congregation, so there's 18 congregations, I believe. That was 245 million euros that was contributed by them. But I don't have a breakdown of how that number came about or whether there's any ongoing negotiations. Given that the initial negotiation on that was 2002, and then the further commitment was 2009, I don't know whether, I mean, that's obviously a while ago, so I don't know if that's still ongoing. But certainly, if there's further questions around funding that the committee's interested in, I can certainly look into that.
Okay, I had one other question, Chair. On page 11 of your paper, the final bullet point, in 2002 the government negotiated an indemnity agreement with the 18 congregations. Under the agreement, the congregation undertook to contribute 128 million in cash, property and other resources to the state. What is meant there by indemnity? So does that mean that there wouldn't be further claims against the institutions? Yeah. But I would hope it doesn't include if prosecutions
no, it was
were sought.
Civil.
There was opening for a prosecution to advance.
Yeah, so that was in terms of civil cases. So when a survivor, if a survivor accepted the payment made from, or the payment offered from the redress board, part of that was signing a waiver to say that they would not take any civil action against the institution. Just on the point that you made there on current time in terms of prosecutions, that's something that's been one of the major criticisms of what's happened, is that there have been a real lack of those prosecutions, something the UN has also criticised the government for, or the state in general for, in Republic of Ireland, just the lack of... I did write it down in here, I can't remember exactly what they said, but they refer to it as a sort of... they refer to it as a climate of impunity. And that was in 2017, around that fact that there have been so few...
That was in a UN report?
Yes, that was the UN Human Rights Committee, which is, that's in the bullet point actually over the page on page 12. And that was 2017, and that's to do with the kind of the criminal prosecutions and the lack of.
Right.
But the indemnity
is not meant to mean that.
No.
Yes.
It's indemnity in terms of like financial indemnity over civil action.
Okay, thank you.
Okay, Timothy, please.
Thank you very much. Page 9, dealing with the Magdalen Laundries, you note 26.5% were referrals made or facilitated by the state. This may be taking you outside the remit of what you've been looking at, but when you were compiling this, did you draw any comparisons between Northern Ireland and ROI to see what percentage it would be in Northern Ireland?
No, I didn't do, in terms of this paper, the scope was really...
Just ROI?
Yeah, so I didn't look into any comparison, but again, that's something that...
Picking up on Brian's point, page 11, page 12, the criticisms regarding no prosecutions, I suppose this is once again drawn it back to Northern Ireland. Do we know have any prosecutions been made in Northern Ireland as a result of the inquiry?
Again, that's not something I looked into, but if the committee is interested, I can certainly look into it.
It'd certainly be something I would be keen to explore, and same idea when it comes to the waiver. On one hand, we're offering you money, but on the same hand, we're tying a hand behind your back that you're not able to take that any further regarding civil. I'm hoping the same thing doesn't exist here in Northern Ireland.
Yeah, that's certainly one of those criticisms in terms of survivors saying felt they were kind of forced into taking whatever the redress board offered them. Now, obviously, they were doing it they weren't just offering a random amount of money, but nevertheless, survivors felt that, as you say, they were kind of being told, if you don't take, you take this, but you can't go through the legal system. But obviously the legal system is a lot more, an even slower and more difficult process. So they did feel a bit kind of cornered into taking the amount.
Is it possible when we're writing to the department we could clarify that? Is that something that will be set out in the framework? And I know Paul's dealing with the institutions, but is that potentially a demand they could make? Just to see clarity in that. You've made reference investigations which have commenced into both day and boarding schools. They operated on an all-island basis. If there's suspicion of that happening down south, was there anything in your research paper that you were able to pull out that the same suspicion operated here, that it happened on an all-island basis? Surely if it happened down south, the chances are it happened in Northern Ireland as well.
Yeah, I mean, as you say, some of those institutions were operating. The scoping report didn't break it down into, it mentioned institutions, but it didn't break it down into any sort of geographical area in terms of where on the island that may have occurred. But it was, I don't believe, but I might be wrong, that was the kind of, that was how that scoping report was to operate. It was really just to understand from survivors what had happened and what they wanted to see occur as a but it's certainly, it may be in there, and if it is, I can come back.
During your research, did you come across any examples in the south where, whether it was in a school or other institution, that abusers were moved from the Republic into Northern Ireland?
That wasn't something I came across, but I wasn't looking for. I was looking at the kind of wider processes that have been undertaken by the government, rather than what was done by the institutions, if that makes sense, in response to any of that. So it was more about what the government themselves had done in terms of redress, rather than the institutions themselves. So I didn't look into that, but it wasn't something I came across.
I suppose just to finish off, very, very good piece of work, and it was good to have that comparative. When I met with the Commissioner for Survivors of Institutional Childhood Abuse, she made reference of the robust scoping work that Scotland were doing when they were investigating historic abuse. Is it possible to replicate what we've done for ROI and look at what we've done in Scotland as a committee?
Yeah, certainly.
Yeah.
If the committee is interested in that, I can certainly go away and have a look at that.
Yeah. Let's be finished.
Okay, thank you. Sinead, please.
Thank you. Brilliant piece of work. It really does set it all out nicely for us. I suppose the earlier session we were looking at the historical institutes of abuse and the 50-50. And this here, it's quite interesting when you see the Magdalen Laundries. The referrals from the state was 26.5%. Therefore, the majority of the referrals into the Magdalen Laundries were actually from family and from the church. So, when you're trying to look at who bears the responsibility for that, it's really important that we know, and the same would be probably applied if we look at the mother and babies institutions as well. The referrals are quite different in all of these institutions, and it's, I don't know if the same applies, that the ultimate responsibility lies with the state if they're church-owned institutions that self-refer. I mean, that's not a question, it's probably just I'm trying to work it out in my head where the redress comes from there. And, in the interest of fairness and proportionate contribution, in those instances, it wouldn't be fair, 50-50. Just an observation. Have you any?
Oh, I think you're right, though. It's interesting that these are not referrals.
They're just different referral modes in all of them. They're not one sweep. These institutions.
Yeah, absolutely, and even actually kind of uncovering where those referrals came from in the first place is not a straightforward. If you're talking about things from 100 years ago as well, like whether those records still exist.
Very difficult.
Yeah.
Mr. Dixon is now the chair. I'll just say, can you hear me, Mr. Dixon? In these circumstances, oh yes, we are good.
Want me to propose?
Yes, if you'd like to propose an alternative chair, and if the committee agrees, a temporary chair. Who would you like to propose?
Oh, I propose Stuart for.
Well, no, he's the deputy chair. It's just he's not responding
Right.
online. So
Okay, so
in this occasion,
Who's Claire?
Sure, I never get to the chair, so.
Independent.
a seconder as well, please. Yes. So Emma is the next on the list.
Okay.
Chair.
Unless you want to be next.
Congratulations.
Any further proposals?
No.
No. Okay.
Thanks very much for your paper. I suppose looking at it, it was like, you know, what are the learnings for us? And it's sort of following on from Timothy's question around having looked at a lot of the schemes that have been ran out through the 26 counties. It's probably what not to do and how not to do certain things. So I don't know if I have a question for you as opposed to maybe your thoughts around the alternatives that have been suggested and the criticisms that have came from the victims groups and from others. Have there been solutions offered there, or is that something that you came across?
So I referred earlier to the consultation that was done with survivors in 2019, which is definitely worth a look if you're interested in some of the potential learning. But a couple of interesting things from that. Obviously, as we know, like survivors aren't a homogenous group. So when it comes to memorialisation, most people were in favour of some sort of memorialisation, but not everybody, and some saw that in a different way. Some saw it as the only way that you could memorialise it, as sort of never ensuring it never happened again. Some saw it as sort of education and things like that. I think in terms of the schemes, they were seen as quite adversarial. So around creating a scheme that is not adversarial, you're not it's not as inquisitorial in trying to at a survivor themselves. It's, you know, is there a way that the board can undertake more information gathering themselves without asking the survivor to do that? The advertising of it, as we touched on earlier, was a really big issue. So are there better ways of making sure that's advertised to as many groups as possible? You know, there's social media now, which is obviously reaches a number of people, but it might not reach people at the age that some survivors are. And then also, just finally on that, survivors in Ireland and survivors in the UK. So around some of the research shows around 60% of survivors are still in Ireland, in the Republic of Ireland. Around 33% living in the UK now, mainly in England, and then the rest living elsewhere. But those people resident in the UK have different needs, and their needs are the same in a lot of ways in terms of help with housing and support for medical, financial and other supports. But the jurisdiction that they are in means that support looks different, and that was something that was a criticism of some of the redress schemes, was that they were too centred on those that still lived in the Republic of Ireland and didn't take into account the other jurisdictions and how the support might work in practice for people who live there, in terms of some of that some of that well-being support and social support, rather than just the financial. So certainly there are some really interesting observations in that consultation around that.
Thanks. I just have one more question. I know at the time there was criticism. You've referred to the payment scheme and the two sort of determining criteria in that you spent at least one night there, or that you as a child spent 180 days. And I know that there was criticism of that it excluded a portion of people. How did they come up with that 180 days, or what was their rationale, or where was the...
So there were some recommendations made to the government. I can't remember who it was that had those, but I have got it written down somewhere. And actually the recommendations that were made in terms of that were actually even narrower than the ones that the government went with.
Okay.
In terms of that that women would have had to undertake and work, so it was only really the work that they were to be.
Yeah.
But that's obviously was taken out. So there is work payments that can be made, but you are entitled to a payment if you spent one night. I'm not sure how they came up with 180 days for children. I think it would be in that report, which I can certainly look at. And yeah, you're right. There's Human Rights Commission in Ireland have been quite vocal and others and survivor groups about that. I also think that the entitlement to a medical card for mothers requires them to have stayed for 180 days as well. So they're entitled to the payment for being there for a night, but they're not entitled to the medical card unless they've been there for 180 days. But again, I'm not sure exactly where those numbers came from, but I can certainly look up that report if that's helpful.
Thank you. Thanks.
Okay. Any other questions? No. Okay.
Can I just ask a wee quick one, just about the data? Was it easy getting the data, or was there any difficulties, or was there any differentiation between gathering the data for the Republic of Ireland against trying to get the same type of data up here?
So I haven't really looked into the data up here in terms of that. It wasn't really a comparison that I did.
No.
So, but I think getting numbers in general is difficult for this. When you're talking about the length of time it's happened, the lack of records, and the difficulty people have had in accessing their own records. So it's hard for people to know where they were or what happened to them. I'm sure you'll be aware of that yourself. So yeah, it's quite difficult.
Just looking at some of the figures that you've brought in the paper, we're finding it difficult to tie down some of those figures for up here, and we're in the midst of all of the redress programs, and we're still struggling with actually getting finite figures. So there seems to be easier access.
Yeah, I mean, it's certainly interesting that the Residence Institution Redress Board, had a large number of people applying to that, but then the survivors are saying in the consultation, actually a lot of people we know through the survivors groups didn't access it.
Yeah.
So it's really hard to know what the true number is there.
Okay, Brian, go ahead.
I want to pick up on one question or one statement there. Page 13. There are a number of other methods of redress, including free of charge counselling services, family tracing services. And then continues, family tracing services. What does that refer to? Was there any support? Maybe it's a different line of work, for children who were removed from their mothers. Is that what that's referring to, or is that something else?
I think that's the support in terms of the people who are. That's kind of in line with some of that legislation that's been made around allowing people access to their birth certificate and adoption information and things like that, and that's assistance to help them trace family or see where it was that they have been. I don't know the details of those services specifically, but
there are services here.
Yeah,
right. It's another whole.
I
for
think
every mother there was a child.
Yeah, and I think that's the thing which I said at the start, is that redress, whilst the financial side is hugely important and very obviously important in terms of it does cost a lot of money, and important to people because it can help them move on. It's not the only thing that survivors are looking for in terms of redress, and actually some of these other initiatives could be really important and support for them.
Okay, thank you.
Okay, thank you so much. We'll have a quick chat now about maybe some follow-up research, but for now, thank you, Thomas. Good stuff. Okay, so Timothy's made a recommendation there, or a suggestion there around looking at what's happened in Scotland, because there is some comparable institutions and some unfortunate comparable abuse that we know of. Are we content to take that? Is there anything else we want information on, or? I suppose I would just want to look at the how they got round the GDPR, around the access to birth records, and it feeds very much into your point there, Brian, around the tracing, and this is where a lot of people have found it frustrating because things have, they haven't been able to disclose because of family connections and stuff. So I think maybe that's something to look at, and as well, how they got around it.
Are you saying there is state support available here?
There are some. There is a service. I think the Department of Health actually funds it. Family
Right.
tracing service. Not a lot of people. And then, do you remember we took an evidence session and they talked about that there was guidance that had been issued to all the trusts to bed in around how the social workers would support. And then there was questions as to, you know, how much that was actually bedded in and working effectively and across the 5. So it's quite the guidance is quite new, but the family tracing has been around for a long time.
Right.
But I don't think it's perfect.
So just to clarify, Chair, that's another separate paper looking at a similar scoping
Yes.
study for Scotland.
Mhm.
Do members want to
Yeah.
include England and Wales?
Probably would make sense because
And then just a query there, how they got round GDPR.
I think they've
Yeah.
put in on the statute books, but I do think that that's part of the issue. Because I even think that whenever Sean and Leanne were here, they were even having trouble themselves accessing what was at the Public Record Office, you know. And so anyway, I think that there's sometimes we can be a wee bit officious. Okay. So thank you, Sinead.
Was there a recommendation here for adding something to that letter to the department around
Oh, yes.
indemnity, whether there's indemnity in Northern Ireland? Was that your query?
Compared to, so they raised concerns that when you're offered money,
Yes.
that basically then there was an indemnity, you couldn't pursue that any further.
So the committee would like to add that to the letter we're sending to the department, just to ask if that indemnity is in place here.
Yeah. Well, effectively, is this process almost like a group action as such then? And perhaps it does mean that people can't pursue an individual civic case, but I suppose just for us to have clarity on that
Yeah.
then.
I think some of them did go because they were so frustrated that the redress board was taking so long, but yeah, I'm not sure. I need to get clarity on that.
One item question from Jerry.
Oh yeah, so Jerry just texted me there just while we were chatting to say that he would like a question around what is the cut-off period for total contributions from institutions thereafter the 2nd of April 2025, and I think that speaks to our concerns about what happens if there's a cut-off point and they have made the contributions and then have to go into mediation. So I think it's really just to get a bit of clarity as to what they envisage as when the next stage would be triggered, I think.
That would apply to the lump sum and to the specialised services moving forward.
Yeah. Okay, content we add that. Okay, members, moving on quickly with a piece of legislation here to look at. Okay, so item 8, the SL1, the Northern Ireland Climate Commissioner Regulations, Northern Ireland 2024. So you'll find the clerk's brief, page 49, the SL1 letter, page 52, draft statutory rule, and then 56, and then on page 62 you'll find a memo from the clerk of the Agriculture, Rural Affairs and Environment Committee. So members, the Executive Office is proposing, subject to the draft affirmative resolution procedure, to make a statutory rule which will allow for the Executive Office to establish an independent office to be known as the Northern Ireland Climate Commissioner under powers conferred by Section 50 of the Climate Change Act Northern Ireland 2022. So members, the committee sought the views of the Agriculture, Rural Affairs and Environment Committee, and their response indicated that they have no objection and have made no recommendations for amendment. So I just seek your agreement to write to the department to ask what the establishment cost will be for the office, and to confirm whether the office will remain with TO after it has been established. Are we content to write and find out about that?
When you're talking about establishment, what all are you asking how many jobs, how much it's going to cost?
Well, we should ask for the breakdown, yeah. So we ask
The
for the
structure,
yeah.
what it looks
Organisational structure, okay. Content, we'll write that. So members, also before making these regulations under the Act, the Department must request advice from the Committee on Climate Change at Westminster about the proposals to make the regulations, and to take this Committee's advice into account. And engagement on the regulations with the CCC is ongoing, and that final regulations will incorporate any suggested changes from that committee. So I would seek your agreement that we withhold consent to the regulations until any amendments recommended by the Climate Change Committee have been returned and incorporated. Are we content that we withhold consent until then? Do you want me to repeat that, Brian?
Yes,
You okay?
yes, repeat
okay.
that.
Okay, so Before making regulations under the Act, the Executive Office of the Department must request advice from the Committee on Climate Change at Westminster about the proposal to make the regulations and to take that committee's advice into account. That engagement on the regulations with the Climate Change Committee is ongoing, so it hasn't finalised yet. So the Department has said that the final regulations will incorporate any suggested changes from the Climate Change Committee. So what I'm saying is, until that process has been completed in terms of the engagement and response from the committee in Westminster, we should withhold our agreement for these regulations to be...
It's a committee at Westminster.
Yeah, so the department here has to consult, and they have to come back and suggest perhaps some amendments to the regulations, but that they haven't done so yet. So I'm saying we should wait until that process has happened. Is that okay?
Do we have an idea of the timescale or no?
We can write and ask. Yes.
Okay.
Yes, because obviously there's a huge interest in this commission coming into post. So, okay, we can put that on it. Okay, content we move on? Okay, so the draft Programme for Government Committee response. So, as you are aware, the committee is responsible for the collation of responses to the consultation on the draft Programme for Government. The committee had written to other statutory committees seeking their views on the consultation. The department had agreed to extend the consultation period to the 22nd of November to accommodate the response from our committee, and you'll find the draft committee response at page 65 of the pack. Has anybody got any comments on the draft response, or if they would like to put forward any suggested amendments?
Noted.
I think it's very, very factual, and I think you had indicated that not all committees wrote back, and that we as a committee ourselves didn't take necessarily a view on the draft Programme for Government, so it was probably quite informative as opposed to a subjective view. People find okay that we go ahead and submit that?
Yeah.
Okay, thank you. Sorry, you've suggested if anybody has any amendments to email them through before the 22nd, but...
Well, if the committee's content with as it is, then I can just send that.
Okay.
Yeah.
Okay, well, that's great, thank you. Okay, so just an update on the inquiry into equality legislation and your comment earlier, Timothy, around the invitation. The Assistant Clerk will chase that up, but we have been asked by the Equality Commission if they can attend the event on the 4th of December in an observatory capacity, and if people are content with that, that's okay. And again, if there's any other groups or organisations you feel that should be invited, please send it through. Okay, getting there. Draft Forward Work Programme. So you'll find this at page 77 of the meeting pack. The first meeting back of the committee following recess at Christmas will be Wednesday the 15th of January. That allows a week for the staff to get the committee pack pulled together once they come back from their Christmas break. So that's what that is. So in terms of scheduling for meetings, we had said we would like to look again at racism, refugee and asylum issues by inviting mayors, the Housing Executive and Migrant Help. Also within that session, I think that it might be useful to bring the PSNI. People will have received an email yesterday about their draft, I think it's signed off, Race and Ethnicity Action Plan, because as you'll remember from the evidence session, the stakeholders had indicated that they felt that the communication wasn't great, the investigations, etc. So I would suggest we would have one session to look at that again, and by inviting the Housing Executive, that would allow them the opportunity to respond to the accusation of institutional racism, but also to talk about how they support people when they are. Is everybody content with that as a session?
The only comment I'd make on that is, I mean, people can present whatever views they want to us, but just that we're not presenting that as in any way as our view. It's representing the view of the
this
committee,
is giving them the opportunity to address.
And at times we have the right to challenge people back, and express a view on the view they're presenting to us. We value their experience, and their perspective, but just that we also we have to weigh up what we're being told, Yeah.
And that's why I think it's important we allow the Housing Executive to come in. Okay, so just the other issue I raised under Chair's business was around the mother and baby consultation engaged with, just one wee second, in terms of consultation, and I think that maybe another session where we certainly invite those people with lived experience of mother and baby institutions to come before us in terms of the whole process around the Trust Recovery Independent Panel, but also that we ask the department to come back and give us a briefing on the consultation into the public inquiry and redress. Is that okay? And then I think there's just a session on effective questioning that other committees have had, so we'll try and get that in. Timothy, have you got a suggestion?
27th of November. Stakeholders of victims and survivors. What groups are coming that week?
So far, and the assistant clerk might assist in this.
So confirmed is the South East Fermanagh Foundation. They'll be appearing by video link. Then we have the Pat Finucane Centre and we have Trauma Centre. They're the ones that have confirmed.
Was there 5 altogether?
We invited 5.
Okay.
And the Relatives for Justice couldn't make it. And also the Ulster Human Rights Watch are going to send a written briefing instead.
So will that be one panel?
That was the plan, yes.
Yeah. I don't think there's been an indication, and in the past we have, you know, where there's been, I remember when HIA we separated, so if there's...
Could we just check to make sure that there's none of the victims groups have an issue appearing alongside other ones?
During the invitation, we advised that the other groups that have accepted and have been invited, so we haven't had any objections so far, unless that's the reason for the group appearing remotely.
Which is why I'm raising that. It's something to be mindful of, and if it means getting a group to come in instead of coming via video link, because I think it's good to have them in the room.
Sorry, just through the chair, Mr. Donaldson from the South East Fermanagh Foundation said that the reason he couldn't come in person is because he had an event to go to in Fermanagh at 3:30 or something, so he wouldn't have been able to get back to Fermanagh in time.
Well, that's grand if that's the reason, but it just would be saying to be mindful of putting 2 victims groups together that maybe couldn't agree on the likes of the definition of victim. We have to be very mindful of that.
Can you maybe go back to the other 2 groups and see, because in terms of maybe scheduling them at another time, because obviously we know that we have to do amazing work, for example, and you know, I think it's useful that we keep refreshing our understanding of what victims and survivors are experiencing. Okay, members, just moving on quickly then in terms of correspondence. You'll find in your pack correspondence from the Committee for Agricultural Environment and Rural Affairs on the Migration Advisory Committee review regarding seasonal agricultural workers visa review recommendations. The Minister would like our support in terms of writing to the Executive Office around this. Did anybody get a chance to read it?
Yeah.
Are you content we would write to the department?
No,
just to,
absolutely.
Yeah.
Because I know I checked with Michelle McElveen, as a member of the Agriculture Committee, and she had raised the question with the Deputy First Minister in the House, you know, and you know, particularly in agri-food, you know, the seasonal workers coming in are very much needed. And
I think it's TEO have to write to British government.
Yes,
but we have
it's
to ask the
DEFRA.
TEO to ask that. Yeah, sorry,
With those temporary work visas, you know, in the mushroom
all
growing.
For pre-Brexit, those people could come in.
But well,
protocol.
It's not just from European countries. You know, there's a lot come from the Far East as well, Philippines and places like that. So you know, in the fishing industry, you know, as well, we're very much in our agri-food sector rely on those seasonal workers.
Yes, no, totally. It was more just to ask our
Their support. Yeah.
Okay, there wasn't very much correspondence this week, but was there anything else? Obviously the stuff Jerry had sent us, which was very useful. Okay, any other business? Go ahead, Claire.
I haven't notified you of this, so feel free to tell me to go away. But do we have a role as a committee given the FM and DFM's role around the democratic consent motion? So they have a responsibility to call it, and if they, you know what I mean. Do we have a role then?
So I think the Secretary of State at the end of October, I think that he brought forward the motion or something. So Was there not something? There definitely was something.
There's something where he says he's done something, but then I believe the next action is that either the FM and DFM have
I
to
think
call
the date
it.
for them. I think the date for them to bring the motion has passed.
Right. Okay. So,
So that's why
The DUP have already said that Junes aren't bringing it.
Yes. So the Secretary of State has taken it forward, and I think the vote has to be by the Tuesday, 18th.
Is there any value in asking FM and DFM why they weren't bringing it, given that it is part of their responsibilities as FM and DFM?
We already know the DUP.
No, I know, but officially.
Yeah. I'm happy for that. Yeah. Because I'm
yes. You know, I'm keen to.
Who would we be writing to? Actually,
the
to
First
the party?
Minister. Well, my understanding is that there is a process, and that process begins with the FM and DFM, and as the direct scrutiny committee of the department, should we not be asking them why they didn't fulfil that? Just for our information.
Okay. Okay, to the ministers.
Yes, I think so. Yeah.
I'm happy.
If they can't agree to bring it, surely they couldn't agree to come back to us why they're not bringing it. If you get me.
Well, I suppose what I'm saying is that if they can't, then I want to understand why is the accountability committee, if you like.
No, I think that's a good idea. I think just for the public record.
Yeah.
Okay. Do we need to put that to the vote, or is everybody content?
Yeah.
Well, I take a box, go on ahead.
Okay. Any other business? Okay. Thank you, members. So our meeting's 27th of November. How have we got to the end of November?
Committee Room 30, Sound.